To make a start, in this lecture we will be thinking about the doctrine of precedent. I'm going to begin with my normal excuse. It's quite difficult to explain the doctrine of precedent in one lecture. If you were a law student, you'd spend certainly longer than one lecture thinking about this topic. In fact, you could almost say you'd spend your entire degree, the 3-4 years of your degree, engaging with the doctrine of precedent, because the reality of the doctrine of precedent is it's about reading. It's about reading cases. It's about understanding judicial reasoning. It's a practice, if you like, and to understand a practice you have to be part of it. You have to be embedded within it. We can't do this, so we're going to have something of an overview, but I'm hoping that I can give you the important points about precedent and a flavour of how it works, a sense of how this doctrine works, because it is so fundamental to the common law. It is the way in which the common law develops. Let's return to our working definition, the working definition of precedent that we have used in the past, and that is that like cases are decided in the way, or cases that are considered alike are decided in the same way. Let's try and think about what this might mean. I said cases that are considered alike. What do I mean by that? Well, I mean alike in law and fact. Now, this is a rather technical distinction, but I think that we can get the gist of it if I just focus on one of the cases that we've thought about in the past, and that's Lloyds Bank and Rossett. I can do this quite briefly. The facts in Rossett concerned the couple who had renovated a derelict farmhouse. One couple was the title owner of that farmhouse. The dispute was whether or not the non-owning spouse could claim a share. Now, we remember our analysis of this case took us to equity and the way in which equity, or an equitable device like a constructive trust, might be able to obtain a share of that property for the non-owning spouse. So we can see, in other words, the mixture of law and fact that is at stake here. The facts, as I've said, relate to the purchase of the farmhouse, etc., who held title. The legal issue, we could say, relates to how that equitable device, the constructive trust, may get the non-property owning partner, spouse, a share in that property. So obviously it follows from what I'm saying that if another case comes along that is considered by the presiding judge to be sufficiently alike in law and fact, it would be bound by the case, by the decision, by the rule of law in Rossett. I want to carry on with this line of thinking because I think there's some matters of definition that we need to deal with at this point. So let's try and rework our working definition of precedent, or the doctrine of precedent, in order to bring some of these points to the fore. What I could mention to you, this reworking, is it would go something like this. If the instant case, the case that the judge is trying to decide, is considered sufficiently alike in law and fact to an earlier ruling in a precedent case, then the instant case is bound by the ruling in the precedent case. That's our elaborated working definition of precedent. I'm aware that there are some words in there, some words that I want to define, but I'll define those in a moment because I want to draw your attention to what I think are the two key features of what I've been talking about, the two key features of the doctrine of precedent. Firstly, that precedents are binding. Now, what do I mean by this? If you cast your mind back to the time we were thinking about the distinctions, or at least one of the distinctions, between civil law and common law, we were saying that what characterises civil law is a binding code. Precedents in civil law tend to be illustrative and not binding on that code. That's because the code is binding. In common law, precedents are themselves binding. There is no code. So what we're looking at when we're looking at the doctrine of precedent is a doctrine of binding precedent. So, first point, precedents are binding. This takes us to another theme that we have also explored, and that is the hierarchy of courts. Now, the hierarchy of courts is a fundamental feature of the doctrine of precedent. The rule of thumb is as follows. The courts superior in the hierarchy bind the courts inferior to them in the hierarchy. Now, I know it's more complicated than that, and if you cast your mind back to our work on the hierarchy of courts, we saw that courts have both trial jurisdictions and appellate jurisdictions, but I'm not going to revisit those themes. I think this comment that I have here, this definition that I have here, that courts superior in the hierarchy bind the courts inferior to them in the hierarchy, is workable for our purposes. What this means in practice is that precedents are determined by the more superior courts, in other words, the Court of Appeal, Civil and Criminal, and the House of Lords or the Supreme Court. I'm leaving to one side at the moment the European Court of Justice and the European Court of Human Rights. Those are themes that I want to deal with separately. I'm talking at this point primarily about the hierarchy of the domestic courts, the courts of the United Kingdom. So let's just stick with this point and make sure that we understand it. I think what I have here is a quote from one of the major commentators, one of the major scholars in this area, Cross, who writes, "What characterises common law system of precedent is the respect paid to a single decision of a superior court and the fact that a single decision is always a binding precedent as regards the courts below the court which issued it, or the court from which that precedent case emanated." In other words, that gives us, I think, our two key ideas here. Precedents are binding and the hierarchy of courts is of fundamental importance. There are a couple of other terms of art that I want to explain for purposes of clarity, although these, at least some of these definitions, are remarkably slippery in some ways. I've been referring to a precedent. I've also been referring to a ruling, or to give it its Latin title, the ratio decidendi, or the ratio of a case. Now, our working definition of this term is going to be the ruling or principle, the rule of law, if you like, or the principle of law, for which a precedent case stands as authority. Now, that's one definition. I'm aware that there are others, but when I refer to a ruling, when I refer to a ratio, when I refer to a rule or a principle, a precedent rule or principle that's binding, that's the thing that I'm referring to, the ratio of the case. Now, there's a way of distinguishing between the ratios of cases and everything else that, if you like, is part of a case. The distinction is between ratio and obiter, obiter dictum or obiter dicta, singular and plural. The obiter is everything else said in the case. I said a moment ago that law is about reading cases. And I think these terms really start to become important once you sit down and actually read a case. You will see where the ratio is. You will be able over time to distinguish between ratio and obiter. This is the work of the lawyer, it's the work of the law student. Given that we're not really engaging, we haven't got the time to engage with the reading of cases, with legal reasoning and legal rhetoric in detail, I've got to leave these points to one side. But as I explained in an earlier lecture, the trouble is everything is connected. I can't explain one thing without referring to others. So I'm hoping that these working definitions will see us through our understanding of this lecture, of this doctrine of precedent. Okay, so where we're going to go next is to think about the actual structure of the courts. The cases that we're going to think about relate primarily to the House of Lords and the Court of Appeal. Again, I've got to do this by means of a snapshot. I'm not going to look at all the relevant cases. I'm going to look at some of the key cases that I hope are illustrative of both the functioning of the hierarchy of courts and the tensions that have developed within this system of hierarchy, within the system of precedent over the years. The final point that I want to make for the moment is, I suppose, a general point about why we're concerned with these technical details. What's the underlying reason, the underlying concern with the hierarchy of courts, with the doctrine of precedent? Well, I think they're essential to judicial lawmaking. They make judicial lawmaking, as far as possible, coherent and consistent. They provide, if you like, a structure of argument. Now, this is fundamental to the law. Legal decisions are not arbitrary. Judges must give reasons for their decisions, and to a certain extent, or to a large extent, the decisions that judges are making must be seen as coherent with the decisions that judges have made in the past. In other words, that's when I said that judicial lawmaking needs to be consistent and coherent. That's what I meant. The structure of precedent is fundamental to judicial argument. We could say in some ways it's fundamental to the rule of law or to justice according to law. Points that I'll try and pick up on as we go through. They're not going to be the main points of this lecture, but I will pick up on them as we go along.